But we're happy to ask questions.
This morning.
We're happy to ask questions. But let me go through. Happy to ask questions, number one. Okay. Number two, we have to have some independent verification of answers.
I understand that.
Okay. That's it. Those are my 2 points.
Okay.
Okay. So we're happy to ask questions, but we have to have independent verification.
Does the appointment of a trustee, does that affect Sussman Shank's role? I mean, are they less involved now the trustees really have to really move forward and do whatever they need to do? Or I don't understand what does it affect their role going forward?
As a practical matter, it doesn't probably. As a legal matter, the trustee can select whatever trustee wants to be honest. So.
Does the Sussman, listening to what I've heard so far, it sounds like we're frustrated with the speed of this process. You guys are frustrated with the speed of this process, and of course the big part of it's not here. Sussman Shank is, maybe getting some of the blame and stuff, at least inside me, and with this next process with the trustee appointments, does Sussman Shank's, will their role go down, which I think might be a good thing, but
well, we need to get the legal work done no matter what, right? Mm-hmm. They clearly are the most knowledgeable firm. Mm-hmm. They are. We need, once part of this problem is that because of the intense distrust by the creditors, you get a lot of duplication.
Right.
Mm-hmm. It doesn't help.
Right.
And I think once we get the trustee in place, I think everybody will agree to stop the duplication, because then the creditors will feel like, okay, they got their guy in place, so they don't need to duplicate. And that's part of the role of the trustee, is to say, okay, creditor's attorney, you research this issue. Sussman Shank, you research this issue. And we need to move forward on this, and this. So.
It seems to me that they're going to appoint a trustee, and then the trustee just, would be, if it's you, then when does the assignment of interest happen?
Well, that's dependent upon the four principals deciding that they want to do it or don't want to do it. And other than a court, nobody can force you to do it.
Is there does it make sense that we sit there and go, okay, here's all these assets, we're ready to sign right now?
Oh, that's mine, sorry.
Here's these assets that we're ready to transfer, whatever, or sign or whatever. And then we have these other ones we're really, really concerned about. We want some kind of different agreement to get those in. Is that unreasonable?
I'm not saying it's unreasonable, but Mark, you've asked me the same question 5 different times, and my answer is the same. You're asking for an answer. I'm telling you, people are literally researching that question today.
But you also just said that until
I was just saying, quit researching it. I'll agree to get this over to you, but let's do this in a different way. This is an asset that has nothing to do with inland. I will give it to the bankruptcy estate. This is how I want to do it in a way that doesn't endanger it. I don't need the attorneys to tell me, oh, well, we're going to take this risk or whatever. This is me. And I'm subjecting, so I'm asking you, are the attorneys going to say, you have to do it, you don't have a choice?
They might. They might say, if you want the cooperation of the creditors, this is what you need to do. They can't say to you, you have to do it. Only a judge can say to you, you have to do it. But they can say, if you want the cooperation of the creditors, this is what we want you to do. That's why they want to research it, so they can figure out what exactly they want you to do. And asking me again and again isn't going to help, because I don't have an answer for you today on that issue. It's been raised. The initial reaction was, let's put all the assets in and take the risk. That was the initial reaction. Then David Foraker and others said, come on, guys. think about this. Let's make sure that this is the right way to go. And so people said, okay, you're right, we should go back and revisit that. And that's what they're doing. They're revisiting that exact issue. But I can't tell you, Marc, I understand your agreement. It's a good idea, it's a creative idea, but I can't tell you whether that's, people are gonna agree to that or not, because I don't know. I don't control the creditors, so I don't know what they'll agree to.
But if you can voice your opinion.
But if you have influence with the creditors,
That's
I mean.
I influence them by saying, you gotta go research this, don't just do it this one way, let's go research the issue. Let's figure out if there is another way to do this. And then we talked about all the different ideas, which I've gone through.
And what about you presenting this idea to the creditors?
He says he already
just
has.
did.
Oh, this one with him signing some?
No, I didn't
Just
present exactly
blank-
that idea.
There's
but-
problems with blanket assignments, just assigning everything, if there's some issues there. You've told the creditors that.
Yes. And not only that, I told them, what about doing it with a assignment of economic interest with a power of attorney? What about doing it with an assignment of economic interest and a cooperation agreement? You're proposing something kind of like my third alternative.
Right, that's kind of,
It's
yeah.
kind of the third alternative. And
And
so
then-
I've said, analyze these ideas.
And maybe it makes sense if some assets go one way and some assets another way because of this.
It might.
Can you-
I'm not
Can you keep just a court order in place on specific assets and transferring those assets, that court order's there under this agreement of cooperation or whatever? So they have assurance that it's, it's a court order giving assurance that it's not going anywhere.
You're asking me to interpret the court order?
I don't know.
I mean, I don't know, I'm sure if
I guess
I.
I'm asking, do you think that the creditors would look at that as a strong enough thing to give them assurance that?
I don't think so. I don't think that existing court order is enough to give them that assurance. I am told that some of those creditors are gonna continue to pursue their actions that they're pursuing unless the assignment is done. But again, not my decision, I'm just telling you what they tell me. And I've said, let's think about these other ideas as a way of still getting everybody in the same page.
Is there, could you, email me the 3 ideas that you have, just word by word, so we understand what they are? Or are able to talk to the attorneys that we have to deal with in order to.
I had tried to call David Porter on the way down and couldn't call him because I had 3 other phone calls at the same time. I'm gonna call him on the way back, because he's asked me specifically to call him and talk to him about not only this issue, but about a couple other ideas that he's got.